people can see and hear us.
Okay.
I always like to mention that to people.
Do we have anybody logged on yet?
No. Okay. Yes. Okay, where is record? All right, audio, video, yes. Oh, pause, stop recording. Okay, we are recording. Okay, so hello, everyone. Welcome to our latest installment of the Lunch and Learn program. We have with us today two of our own lawyers. We have Jane Harrington and John Robbins. Just to give you a bit of background, Jane articled with Legal Aid back in 2018, 2019 at our Real office. Sandra Bracken was her principal at that time, who is now our Deputy Executive Director. She did a brief term with Legal Aid Ontario after articling in the Kenora area. She came back to Legal Aid Manitoba in March of 2020 and was duty counsel throughout most of the pandemic. She moved to our Regency office in 2021, and she's been there ever since. Jane has practiced primarily in youth criminal law, but also has the circuit in Little Grand Rapids. So she has a little mix of everything there. She currently also supervises our prison law rotations. And when she's not working, just to give you a bit of personal background, you can find her vacuuming husky fur in her home or her vehicle or lint rolling it off of her suits. And as far as John didn't really provide much of a bio other than John is a lawyer at the Riverwood office. And that's all everyone needs to know about John. So with that, I'll pass you on to Jane and John. And let me know when you want to share your screen.
Okay, yeah, you can.
Sure.
Yeah, so I do have a PowerPoint presentation for everyone here.
So if you guys could just let me know if you could see just 1 second here, developments in youth law. Does that come up right now? If somebody could unmute and let me know. Anybody?
I don't see it, but I'm also on a mobile device.
I'm not seeing it either.
So Mark or Stacy, can you let me know? Can you guys see the developments in youth law?
I don't yet, no.
Trying to talk.
I can't hear you guys. So Stacy, it looks like you're trying to talk here. Someone could put in the chat if you could.
Can you hear me now? I can't see the present. Oh, hold on a second. Something's loading. Okay, I can see it now. Are you able to hear me?
What did I just do?
Are you able to hear me? I can see it now.
Chat. Just give us a second here. We're just trying to make sure that this is working. Chat, if somebody could write in chat or let me know if you can see the screen.
Oh, yeah, it looks like she says we can see.
Perfect. Okay, well, with that, then I will pass it on to Jane, and let me just start you the slideshow at the first slide. There you are.
Okay, thanks. I'll just use the mouse. Thanks.
Oh, it's easy to do.
All right. Okay, thank you guys for having me. So I'm presenting on developments in youth law, which was one of the topics that was presented on at the Halifax conference that we attended in July. So thanks to Legal Aid for sending me. I did learn a lot there. It was actually our very own Sandra Bracken who presented on the complex issues in youth law. And as you heard, she was my former principal. So I will be sort of following up on what she presented on. So I guess I'll start by saying sometimes people tend to think that youth lawyers are sort of the lesser of the criminal lawyers because a lot of the sentences result in probation orders. But I'm here to tell everyone that that's not true because in fact, youth lawyers have to be experts not only in the criminal code, the law of evidence, criminal defense, but as well they need to be experts in a second piece of legislation, which is the Youth Criminal Justice Act. So as I'm going to discuss in a little bit, youth law is very complex, not only because you have to deal with those two pieces of legislation, but because youth can also be sentenced as adults. So they are liable for very lengthy jail sentences as well. So the first issue I want to talk about is the issue of delay that arises in youth cases. So the leading case is the King versus KJM, which came out in 2019. So it was just before the pandemic. I feel like maybe people forgot about it a little bit. But essentially what happened in this case, it was a 15-year-old who was charged with aggravated assaults and possession of a weapon for a dangerous purpose. Briefly, the facts were that the young person was at a house party. There was an argument with another kid, and the accused stabbed a youth in the face and the back of the head with a box cutter. The youth pled not guilty, and he was arguing that he was acting in self-defense. The case went before the Supreme Court, and the question for the court was whether or not the ceilings that were set out in Jordan should apply to youth in the same way, or whether or not they should be lower. So the question, do the presumptive ceilings apply to youth prosecutions? And the Supreme Court decided yes, they do. It's an interesting case because this was not a unanimous decision. So the majority in their decision, they acknowledge that young people have the right to have their matters heard in a timely manner for 5 reasons. Number one, young people have a different perception of time and a less well-developed memory than adults. That a prolonged delay dilutes the effectiveness of disposition. Number two, that, a few months in the life of a child compared with adults may acquire greater significance. So I like to think of that one as, summer used to last forever. Number three, preserving the right to make full answer in defense. They basically touched on that memories fade faster for young people. And when a long time elapses between the offending conduct and the punishment, that this creates an issue in terms of whether or not the young person can remember things appropriately and obviously then affects their right to full answer in defense. Also, that there's potential unfairness in terms of cases not proceeding quickly. Behaviors change in the life of a young person a lot more than they do in the life of an adult. And so when we look at whether or not, if the prosecution isn't moving quickly, that the attitudes and sort of the whole personhood of the young person may have changed so that they are effectively, a different person by the time they're actually sanctioned for their offense. And then lastly, the society has an interest in moving youth prosecutions along quickly because we want young people to be rehabilitated and reintegrated into society. So as I said, the decision was not unanimous. There were 4 justices that said that Jordan is fine. So the 18 months in provincial court and 30 months in superior court are appropriate ceilings for youth. But they, in this case, the case was just over 18 months, and they did attribute some delay to the defense. And so no stay of proceedings was entered in this case. The 3 justices, though, said that the ceiling should be lower for youth. And they went through the analysis of the majority as well. But they decided, and I think that they were correct in deciding that the ceilings ought to have been lower. And then finally, one justice, Karen Stakis, said that the Jordan ceiling for youth should be the same as adults, but they would have stayed the charge as they didn't attribute any delay to the defense, and it was over the 18 months. So again, in this decision, the court was relying on Section 3 of the Youth Criminal Justice Act, which sets out enhanced procedural protections to ensure young people are treated fairly. And they really focused on obviously the timely intervention that reinforces the link between offending behavior and its consequences, and the promptness and speed with which young persons responsible for enforcing this act must be given the young person's perception of time. So again, I think it's important to remember as adult lawyers, when we're assisting youth clients, that their perception of time is quite different, and that is codified in the Youth Criminal Justice Act. And even though the decision in KJM was that the adult ceiling should apply, it's a good read because it really goes through, the differences in terms of the time perception of young people and adults. A little bit confusing in terms of what the majority said, that because of the enhanced protections under the YCJA, that if the accused were to make an argument that even though it fell below the ceiling, that there was still an argument for the case to be stayed due to delay, that the youthfulness of the offender and the act should be considered, which the dissenting majority said, well, that's just making things really confusing for everyone now, because you're saying on one hand that they can have the same ceiling as adults, but that on the other hand, they're very different, and that if it was below the ceiling, that should be considered in terms of whether or not a stay ought to be granted. Yeah, so I sort of align with the dissenting majority. They indicated that 15 months should be the ceiling for youth matters. They said, use this language, which I thought was pretty blunt, that cramming youth criminal justice proceedings into Jordan simultaneously changes how the system treats young persons and changes Jordan itself. Applying the adult Jordan ceilings to young persons erodes the standards and contradicts this long-standing understanding and practice, and it bizarrely leaves young persons worse off than they were, since the adult Jordan ceilings potentially allow for more pretrial delay for young persons than in the system previously tolerated. So in the Morin system, essentially the guidelines for youth were actually that the ceiling should be lower. One of the common reasons that was discussed in this case for why there can be youth delay is for the extrajudicial sanctions that the Act asks the police to consider before laying a charge. And so there was a question as to whether or not, if a young person was referred to diversion, and that diversion program fails, should that time be included in the calculation? And essentially the Supreme Court said that removing this delay from the Jordan calculation minimizes the risks that authorities will refrain from using extrajudicial sanctions in the first place, out of fear that they might be increasing the likelihood of a stay. So they said, largely that it should be included in the time calculation if they fail out of diversion, because again, it would sort of curtail potentially the police referring a youth to that program if they thought, okay, well, if they don't succeed, then there's a greater chance that this charge will be dropped altogether. But the court also said that, of course, it needs to be assessed on a case-by-case basis. Okay, so the next topic, I'm just going to shift over now to adult sentence applications, which I would say is a very complex area of law. We're seeing more and more of them in Manitoba as we see what at least I perceive as a rise in violent crime in our communities. And if you do have an adult sentence application, if you're given notice by the Crown, please reach out to us at the Regency office, because not only do we have experience doing these applications, we actually have our very own in-house expert now, Hilary Tash, and I'll touch on that in a moment. It looks like my exciting image of kids incarcerated was cut off here, but Section 72 of the Youth Criminal Justice Act is the section that you're going to look to when the Crown gives notice that they're seeking an adult sentence. And it asks the court it says that the court shall be satisfied, that the presumption of diminished moral blameworthiness is rebutted, and that the youth sentence imposed would not be long enough essentially to hold the young person accountable for their offending behavior. The case that you should look at if you want to dive further into section 72 in terms of reduced moral blameworthiness, which is a principle now of fundamental justice that was established in the 2008 Supreme Court case of DB. This topic came up in the conference because currently the Supreme Court of Canada they're about to hear two cases about adult sentence applications. The case of IM, which I've given a little overview. Essentially, it's a robbery that resulted in a death, and so the young person was charged with murder 17 at the time of the offense. And he was sentenced as an adult. And as an adult, the mandatory minimum is life imprisonment, although parole eligibility for youth sentenced as adults is lower, so he received 10 years. As well, they'll hear that together with SB versus the King. In that case, the young person, I believe was 15, was convicted of first-degree murder for shooting somebody in the neighborhood, and he received a life sentence with parole ineligibility again for 10 years. So the questions that are coming up in the Supreme Court case, which will be heard in October, is going back to section 72 here. So this section says that the youth court justice shall order that an adult sentence be imposed if it is satisfied of both what we call the first and second prong of the test here. And so the question for the court in October will be, what is the standard of proof? We know that it is a crown onus to satisfy the court, but is it a crown onus beyond a reasonable doubt that they have rebutted the presumption of reduced moral blameworthiness? And that the sentence isn't long enough? Is it a balance of probability, or is it this persuasive burden of being satisfied? And essentially what we've seen is in 2007, the Ontario Court of Appeal discussed this persuasive burden. And they said in that case that the court is not being asked to make a finding of fact about past events, nor to make a determination of whether a crime has been committed, which are the types of decisions for which proof beyond a reasonable doubt is normally required. And I mentioned that we have our own expert on this. Hilary Tash has written her thesis about, her master's thesis about adult sentence applications, which I encourage everyone to take a look at. It's very fulsome. But essentially in IM, the appellant is arguing that it should be proof beyond a reasonable doubt, and that, you know, an adult sentence is a more lengthy sentence, and an aggravating factor is a factor that induces a court to impose a sentence that is longer than it would otherwise impose for an offense of that type. So an adult sentence by its very nature is a more severe penalty than a youth sentence, especially in murder, and I'll speak to that in a moment. You know, the difference between a youth sentence and an adult sentence for murder, for example, is 6 years compared to life in prison. So the appellants in this case are arguing that the standard that the Crown should prove is beyond a reasonable doubt, that they've both rebutted that diminished moral blameworthiness, and that the sentence is, for example, in second-degree murder, 7 years is not long enough to hold a young person accountable. So again, we, in our office, and hopefully I am as successful at the Supreme Court, that the standard ought not to be just satisfy the court, but that the Crown has to prove beyond a reasonable doubt. Another question that's being raised in these cases is what sort of evidence is required for an adult sentence application? And the appellants, again, are arguing that expert evidence is required. And that there's concern that without expert evidence, that the courts are improperly relying on common sense and sort of the judge is being asked to act as an armchair psychologist, when really this is a test of, reducing the moral blameworthiness. You have to look at, well, first of all, what do we mean by, reduce moral blameworthiness? And basically in DB, we appreciate that young people have brains that are wired differently, and that underdeveloped brains result in poor decision-making. And it's essentially a presumption of immaturity. Now, if the Crown wants to rebut that, how are they able to do that without some sort of evidence in terms of, their psychological, psychiatric functioning? So in the Supreme Court case, it will be argued that the Crown needs to present that evidence. Obviously, that can be a challenge because, for example, in SB, when a forensic report was ordered under Section 34 of the Act, the young person declined to participate in it. So I think that'll be an interesting question of how can the Crown compel the accused to participate in this type of assessment. And I just had an excerpt here from the 2019 case KJM, where we were talking about time and perception of time for young people. And in that case, the court took judicial notice of the research of Professor Steinberg, who noted that when an underdeveloped prefrontal cortex is placed alongside an overreactive amygdala and ventral striatum, the amygdala and the ventral striatum essentially hijack the prefrontal cortex and compromise the ability of youths to temper strong positive and negative emotions and push them towards sensation-seeking, risk-taking, and impulsive and antisocial acts. So again, this is the presumption that, their brains operate in a different manner. And again, our office and the appellants are of the view that if the Crown wants to say, no, your brain is thinking in the way that an adult brain would think, that there has to be some evidence beyond just what's happened, in the arrest report. And that sort of leads to the next issue that we see as being very problematic, that the Crown reliance on the seriousness of the offense itself. So, the Crown in this province, I hear, and I have a case right now where this is happening, where effectively the Crown's position is we have to seek an adult sentence because of how violent the offense is. And really, in my view, the violence of the offense has nothing to do with whether or not my client's moral blameworthiness is reduced or not. So when the Crown relies, on simply what happened, the facts of what's being alleged here with the offense, we're returning back to what was the old regime where we had de facto, if you were charged with a serious violent offense, that was automatically seen to be an adult sentence application. And so we don't want to go back to that. We want everyone to make sure that they read DB to understand that there is a big difference between the way that the brains of youth and adults function, and that there shouldn't be a presumption that just because you do something violent, that means that your brain is operating like an adult. I'm just going to look at what I have for time here. Okay, so the other topic that was touched upon in the conference, and something that I think, will come up and should come up, is what I mentioned earlier, is that stark difference between the maximum sentence for murder for a youth and the maximum sentence for murder for an adult. So first-degree murder for youth has a maximum sentence of 10 years, whereas for an adult, it has a life sentence. And that's a mandatory minimum. And I see that as being problematic because even though The Crown will argue, well, the parole ineligibility is lower, and that's in the criminal code, that is statutorily lower than what an adult would receive. It still leaves the liberty of the offender up to the Parole Board of Canada. And, with respect to them, I think they do the best job they can, but there's certainly, I haven't seen a lot of lawyers sitting on the board. And I think that when it comes to youth that are sentenced as adults, there's a little bit of confusion there in terms of, what that means and how they should be treated. So I think it's open to, some zealous lawyers to look at whether or not there is a Section 12 challenge potentially to the adult sentence regime that imposes, should you be found guilty of murder and receive an adult sentence as a youth, that the mandatory minimum should stand as a life sentence. So I think it's open to some zealous folks to try to challenge that under Section 12 of the Charter. So yeah, in summary, those were essentially the three topics: were the timeliness of youth prosecutions. So the Jordan ceiling applies equally to youth. In terms of adult sentence applications, we're going to get some more clarity in October about what the standard of proof is in terms of proving those, hopefully. Yeah. And as a final point, that, potentially with those adult sentence applications, is there potential to challenge the cruel and harsh punishment of a life sentence for a person who is still developing their brain? So just remember, if you are feeling contempt for your youth clients, their brains are still developing.
Okay, well, thank you for that, Jane. And we're going to pass it on now to John, and that was a good segue because John is going to cover contempt, but criminal contempt. So
perfect.
If somebody could just let me know that you can now see a screen that starts out by saying, what is contempt of court? So Stacy or Mark, you guys are online. Can you see the contempt of court page up in front of you now?
I think it says those three new messages if you scroll.
Sorry, what?
If you scroll, there's
We
three
can
new
see
messages.
Stacy on,
Okay, perfect.
oh, it says 12:05.
Not
Okay,
sure if
we'll
you can
pass it
hear
on to
me. My
John
mic
then.
isn't working, but I can't see it yet.
Hello, I'm John. This is my talk on contempt of court. You may think contempt of court is boring and not interesting. Quite frankly, I kind of thought that before, but the more you dig into it, the more you realize that you are wrong if you think that. Contempt of court is actually really interesting, and it's one of those offenses that most people know nothing about. And it sounds scary in a way because usually it's in a very, usually it's in the superior court, and usually there's a justice who is very mad. And it would be good if you knew what to do when it comes up, because that's always a good thing. So what is contempt of court? Contempt of court, as you can see from my definition, is described as any conduct that tends to bring the authority and administration of justice, the law, into disrespect or disregard, or basically disrepute. Types of contempt: there's in facie, which is in the face of the courtroom. And then there's ex facie, which is not in the knowledge of the court. So basically outside of court. In facie contempt relates to anything that happens in the courthouse, or by extension, in front of the judge, or by extension in the courthouse itself. Examples you see listed are failure of counsel to appear, failure of a witness to remain, refusal to be sworn or to answer questions, disruptive behavior, or even picketing the courthouse. Essentially, the distinction is if it's in facie, a judge could deal with it immediately and then find somebody in contempt immediately and sentence them immediately if they want to. With respect to contempt that is ex facie, it's a different definition because justice isn't able to do that. So that relates to events that are not actually witnessed by a judge or a court officer within the courtroom or vicinity of the courthouse. This could fall into offenses like failing to obey a court order, like an injunction, large-scale protests, which we quite often see in British Columbia for environmental protests, scandalizing the court. making very serious accusations of bias or criticisms, which are designed to lower the authority of the court, or anything that falls within the sub judice category, interfering with jurors or witnesses, late delivery of prisoners to court, media publications interfere with the administration of justice. I'm not aware of any Manitoba decisions where sheriff services have ever been found to be in contempt of court for late delivery of prisoners, but it seems that's happened in Ontario, and boy, that would be interesting if it ever happened here. It might lead to prisoners being brought on time all the time, but that's not really here or there for today. Differences between criminal and civil contempt. Civil contempt is generally confined to procedure related to a failure to follow judgments or processes of the court when there's litigation between private parties. Basically, if it's between private parties, it's seen as private in nature, and that's what makes it civil rather than criminal. Criminal is words or actions obstructing or intending to obstruct the administration of justice, making it a wrong against the state. The big thing you have to know is that criminal is a lot more serious generally because you get the consequences for it are a lot more serious, really. Criminal contempt is the last remaining common law criminal offense in Canada. It's preserved by Section 9 of the Code. Section 44 of Criminal Code provides a provincial court judge the same authorities as superior court judge to preserve order in the courtroom. There's two processes for finding somebody in contempt for in facie. One is the instanter process. A judge on their own motion may deal with an instance of contempt in the face of the court and basically find them in contempt and sentence them immediately. This is something that's used pretty sparingly. And if a judge does this when it's not necessary, i.e. absolutely urgent, this is found to be a reversible error of law. So it seems to have happened a bit more in the past, but there's not really a great reason to use this process now. And if a judge does use this process now, they're kind of asking to be appealed. So yeah, it's not very frequent anymore. The more common process is a summary process. It's usually based off an oral notice of motion, summary in nature. The general procedure is the judge says, I'm citing you in contempt. And then essentially they're being told that they must show cause why they should not be found in contempt. Next, they're generally given an opportunity to consult with counsel prior to this show cause hearing. And then thirdly, there's an opportunity to make submissions on sentencing if they are found guilty of contempt. Before in facie contempt proceedings are initiated, generally somebody should be warned that their conduct may constitute contempt. And if it continues, they could face consequences. In criminal trials, usually this relates to serious gang-related violence trials. For instance, a witness will refuse to cooperate, either answering questions or be sworn in. A judge will warn them and they'll say, hey, you have to answer the questions, you have to be sworn in. And generally the person says, no, I'm not going to do it. So what the judge will do is they'll say, all right, I'm going to give you an opportunity to speak to counsel. They'll go and speak to counsel and counsel will say, hey, you better cooperate, you dummy, or you're going to go to jail for a long time. And then they'll come back and they'll be asked again, are you going to cooperate? And if they say no, a judge is going to say, I find you in contempt. And for criminal matters, generally they'll be found in contempt in front of the jury. You want to make sure the jury knows that you're in charge if you're the trial judge. And then your show cause hearing is generally adjourned until after the trial is complete itself. So that's a very common one. Next, procedure for ex facie criminal contempt proceedings. Judges usually, they have the ability to initiate it on their own motion. However, it's rare, and generally you leave the initiation and conduct of the proceedings to the Attorney General, that being the Crown. Superior Court has absolute jurisdiction over ex facie contempt. There's no right to an election by an accused. The jury is not available. Criminal contempt can be charged by preferring an indictment, rare. Serving an individual in question a notice of motion. That would be done for like a environmental protest or initiated by the court on its own oral motion. The process is summary. The provisions of the code do not apply. However, they're seen as a guide. Bear with me here for a second. The charter still applies to these proceedings. It preserves the principles of fundamental justice by safeguarding the rights of the accused. All right, so section 708 of the code is also used as a mechanism to prosecute criminal contempt and is far more desirable from a defense standpoint because there's only a maximum sentence of 90 days or a $100 fine. Certain forms of contemptuous conduct can also be dealt with in other ways. Section 139, obstructing justice, section 127, disobey court order, things of that nature. There's been past appeals and past legal arguments that section 708 of the criminal code supersedes a judge's common law criminal contempt powers. Defense makes this argument. Sometimes they say, hey, you have to proceed by way of section 708, and a judge just laughs and says, no, I don't. I can do whatever I want. So if you're thinking about making that argument, don't. It doesn't work. It's a waste of time. Who presides over a criminal contempt hearing? All judges in Canada have the ability to rule over contempt committed in facie before then summarily and without delay. Under section 44 of the code, a provincial court judge may issue a fine, reprimand, expulsion from court, prison sentence not exceeding about 5 years, or binding over with sureties and recognizance. A superior court judge has the ability to refer a matter to another judge. A provincial court judge does not. This is because a provincial court judge only has the ability to deal with in facie rather than ex facie contempt. In practice, you're stuck with the judge who has conducted the matter where the alleged contempt proceedings occurred, even if that seems to be counterintuitive to defense lawyers, especially when a judge in question seems to be letting their emotions get the best of them and may not be very dispassionate or open-minded, which is a common complaint you hear about defense lawyers when it comes to contempt proceedings, in that the judge already seems to have made their mind up. Doesn't seem very fair. The Canadian Judicial Council has said a judge should consider stepping aside if he or she is personally involved or if she has expressed an opinion which might reasonably be regarded as prejudgment or in the circumstances raises a bona fide question of bias, interest, or partially on the part of the judge beyond mere allegation. If anyone in this room ever seeks to have a judge remove themselves from contempt proceedings, and they cite this as the only tool they have, let me know. I'd like to come watch. Also, you may want to pack a toothbrush. Realistically, when it comes to contempt of court, judges can do almost whatever they want because it's a pretty flexible regime that comes from the common law, where judges have the latitude to set the process and make almost any determination they want. So again, if you say, hey, judge, I think you're taking this a bit too personally. If you want to go ahead and make that argument to Justice Taves or Justice Saul or somebody else like that, again, please email me. I would like to come and watch. I'll come in the back of the courtroom and I'll watch. And then I will let your family know what happens next. What legal advice did you provide to somebody, to someone a judge has put on notice for potential criminal contempt and is ordered to seek advice? In our role of legal aid counsel involved in the contempt proceedings, hopefully will happen in two circumstances: providing advice to those put on notice of the possibility of contempt or those already cited for contempt. So I'm just going to deal with the first category first. The most common scenario that I talked about before is then when you have somebody often gang related is refusing or reluctant to testify at a serious offense criminal related trial. You're contacted by the court to say, hey, can you provide some legal advice to this person? They're not cooperating. Usually this person's always very wary of threats and the very real potential for retaliation for testifying. Also, this witness can often be in custody. They'll tell you they're more scared of gang members in Stony Mountain or the ones threatening their family than they are of the court. Fair enough. How do you respond to that? Here's some practical advice, because I like being practical and I find the advice that we get in our job is never practical enough. People always just want to talk about theory like it's law school, and that frustrates me. So here's practical advice. Firstly, tell them if they've already testified at a preliminary inquiry, advise them their evidence from the preliminary inquiry can go in pretty easily at trial if they refuse to testify at the trial. Additionally, if they gave a statement to police regarding what they witnessed or what they knew, prosecutor can make a Bradshaw application to have the out-of-court statement be entered as evidence. And thanks to the Supreme Court of Canada and Bradshaw, that almost always works, basically 99% of the time. So while they may feel they're protecting their interests now, an accused may not feel that way if their evidence is tendered in court anyway, in addition to getting a 2 or 3 year jail sentence, which puts them at risk of being targeted in an institution even longer by those people who are not very happy with them. So really, it doesn't make sense not to cooperate, but, you know, people have to make their own determination. What sort of jail sentence will somebody expect to receive if they don't testify? The Court of Appeal, 2019, Aslan, noted a 12 to 36 month incarceration on a first offense of contempt by persons who refuse to be sworn or testify in murder or serious violent offense trials. Courts across Manitoba and Canada have been pretty consistent that accused who lives a gangster lifestyle also can't turn around and cite the risk of testifying against others involved in that lifestyle as a get out of jail free card or get out of testifying free card, which makes sense to me. Because how can you live that life and say, well, I don't want to cooperate because I'm worried about the consequences now of that life? That makes sense. Next, alternatives to being found in court or judicially punished. Lawyers. In the past, it seems counsel are at greater risk of incurring contempt proceedings for certain behavior like missing court dates. That seems to have shifted, at least in Manitoba, to judges referring matters to the Law Society instead. So I have some interesting cases here for you. One is R versus Pinks, who is a notable defense counsel who's no longer practicing. 1979, he had to be in two places at once, and he did not go to one of those two places. He was cited in contempt and fined $500. Imagine if people who didn't show up to two court dates at the same time or were late were found in contempt these days. That would be an interesting question. The Court of Appeal, the split decision, set aside the conviction with the majority stating, quote unquote, it happens. It wasn't deliberate as these dates were imposed upon him, and he apologized, and this is not the stuff to warrant a conviction for criminal contempt. That seems to be a prevailing attitude these days. If you do that enough, you'll probably get referred to the Law Society, but as far as worried about going to jail, not really. Here is a super interesting case that you guys would like to know about next. R versus Royal. Peter Royal is a very prominent defense lawyer in Alberta. I practiced there before. He's kind of Mr. Smarty Pants. He also teaches courses at the university and is well respected. During COVID, he refused to mask up in the courtroom, and he went tit for tat with the judge and basically showed no respect, and it went really far and cringeworthy. He was cited in contempt. A show cause hearing, this is in provincial court, was ordered and was referred to another provincial court judge who ultimately found he was in contempt. Well, it's not going very well for Mr. Royal. The finding was overturned on appeal because, as we all know now, there's no jurisdiction for a provincial court judge to refer the matter to a different provincial court judge for a show cause hearing. She should have presided over the show cause herself or referred it to a superior court justice. What a lucky guy. Basically a pretty incompetent decision by the original judge who found him contempt to refer to another provincial court judge. And the reason is nobody really deals with contempt of court, especially at the provincial court level. So they don't know this because everyone just thinks, oh, it's something that happens once in a while, superior court with gang issues. So that's why you have to know these things. So when you're a judge, you find someone in contempt, you want to deal with it yourself. Remember that. You can think back to this. And you say, I remember that. John Robbins told me that. Next. When it comes to non-lawyers, oftentimes, but not always, the best course of action for somebody cited for contempt or warned they're potentially going to be cited for contempt is to apologize. You'll most likely see this played out when you're dealing with an irritable client who calls the judge a nasty word. I've seen that before. The judge will then have the person sit in cells if they aren't already in custody for the remainder of the day and then recall them at the end of the day. If a sincere apology is forthcoming, it will usually be enough for the individual to avoid being punished for contempt. This concept has been referred to somewhat as purging one's contempt. It doesn't always work, and it can be risky if the contempt finding has already been made. How do you defend a client cited for contempt? This is an interesting question. I've been here, I've done it. Remember, the conduct has to be intentional or deliberate. If your client didn't come to court because of a medical emergency or some suitable explanation, it can constitute a defense. Unfortunately, there aren't many viable defenses, and often your client's defense is just an explanation. The main explanation the courts deal with is fear of testifying due to threats from others. Almost universally, that won't give rise to an actual defense. However, you should be alive to the potential defense of duress. Some individuals have tried to purge their contempt by admitting the offense and then attempting to relieve the contempt by explaining their actions. Purging contempt on a serious administration of justice matter in front of a superior court judge is likely to get you nowhere. See R versus LaValle 2022, where Justice Saul indicated any consideration of her motivation for not testifying in her personal circumstances was only relevant in assessing her moral blameworthiness for the purpose of sentencing. After LaValle admitted the contempt charge, but tried to purge the conviction. In LaValle, a young Indigenous woman with significant Gladue issues alerted the police to the homicide in question and was not involved in the gang lifestyle. She cited threats to her safety and fear of being labeled as a rat for failing to attend court as a witness. She was picked up midway through a voir dire for her statement to be admitted, and she eventually testified. The judge believed her motivation for failing to attend was fear for her safety, but noted she refused all safety planning opportunities that she was previously given. In both the sentence and conviction appeal, the Court of Appeal surprisingly stated the significance of contender's guilty plea at the commitments of criminal contempt hearing, however, cannot be understated. In our view, for the trial judge, it ended any debate as whether he should be making a finding of criminal contempt. Ultimately, they reduced her sentence from 10 months to 5 months. So the interesting part about this is this: the criminal court, who usually does not really want to entertain a successful defense appeal really in any area, it seems, kind of leaves the door open for duress in the right circumstances for an accused who is not involved in a criminal lifestyle, who is sympathetic and potentially with GLADU issues. I was very surprised that they left the door open and they essentially said, well, if she didn't plead guilty, might have been duress here. Also note that she reduced the sentence given from 10 months to 5 months. Again, you'll have crowns that will say the range is 12 to 36 months. Yes, but the Court of Appeal also says ranges aren't fixed and you can go below or above. You don't really go above for this, but you can go below. Here's something that's really important. I'd caution counsel not to make submissions on how their client's non-cooperation or attendance affected a trial. If your client refused to answer questions to be sworn in, did the Crown seek to tender their evidence from preliminary inquiry or to make a Bradshaw application? Was the accused convicted or pled guilty? You have no idea if the proceedings would have played out differently if you begin to speculate. If you say, well, the accused was convicted in any event, Your Honor, don't sentence my client very harshly. Going down that road is a strategy to get yelled at by the judge. So don't speculate on what would have happened if your client cooperated. Freemen on the land or sovereign citizens are finding themselves the crosshairs of being found in criminal contempt for their failure to acknowledge the legitimacy of the court and basically their efforts to frustrate it. See R versus Hardy, 2023, BC Provincial Court. In that case, Hardy was sentenced to a year in jail for his regular behavior before the court when dealing with an unrelated charge as a freeman on the land, basically trying to frustrate the court. I'm kind of okay with contempt of court being used on freemen on the land in that way, maybe with denunciation deterrence, it'll get the message across a bit more. Unsurprisingly, denunciation deterrence are the primary sentencing considerations for those found guilty of criminal contempt. So if you're going to say, oh, but what about rehabilitation or what about this or that? Yeah, good luck with that. It doesn't really matter. It's denunciation and deterrence. I'm just going to get back to the cases that were here. I thought my eyesight was better than this. My eyesight is not better than this. All right, here we go. So here's some interesting cases you should be aware of in Manitoba. What can constitute contempt? R versus Lee, 2019, Queen's Bench. Mr. Lee took photographs or videos of court proceedings. It was a murder trial. He basically took his phone out and he took like pictures of the back of someone's head a few times, 5 times. This is prohibited by the Manitoba Court's Electronic Devices Policy Directive. The justice in this case found him that he disregarded a request by the sheriff's officer to turn over the phone. He breached the directive by downloading one of the photographs on the Snapchat, and then he lied to the court about not having taken photographs when he was asked. This occurred during a homicide jury trial. He was only sentenced to 75 days in custody. It also didn't help that he was a very bad person and he started swearing at people and he used naughty language and he wasn't very sorry for what he did. So it's not a good idea to bring your phone out and take pictures of people during a murder trial. I was surprised he only got 75 days. I thought he'd get more than that. Next, Sean Gamblin. 2023. I used to represent Mr. Gamblin up in Norrie House about 13 years ago. He's a well-known individual. He actually won at the Federal Court of Appeal years ago when he was given essentially a banishment order from Norrie House. He went to the Federal Court of Appeal. I think it might actually have been Mike Walker or somebody else and had that set aside. So he's been in the legal system for quite a long time. So Mr. Gamblin left threatening and identifying messages on Facebook involving witnesses at his son Jesse Gamblin's murder trial. This was done after specifically being ordered by Justice Kaiser not to identify the witnesses. You got to send a message in those circumstances if you were the trial judge, and that message is 3 years in prison. This was pretty extreme behavior. Mr. Gamblin was kicked out of the courtroom at times, and he was just very abusive. Next, R versus Aslan. I referred to this earlier, and I'm including it here because it's kind of funny. He was a witness at a murder trial. That's not funny. He did not attend and he refused to meet with the prosecutor to prepare for the trial. Also not funny. However, these are some of the communications to the prosecutor that were included in the decision, which are funny. He first said that he was not available to go at all and not interested either. Sorry, good luck with the trial. Next, he communicated that he would be on vacation that week and would not attend, stating, so if you put a warrant out for my arrest, go for it. Nothing I could do. But if a warrant is issued, well, I won't be helping you in court. That's a promise. The justice says, Justice Martin, who's a pretty fair guy, I pause to reiterate that the trial was taking place over 2 weeks. And the next, his last reply was, I told the truth to the first time, can't afford to lose wages anymore. You do what you have to do, Miss Simard. Sorry, I ain't showing up. Well, Justice Martin sentenced him to 9 months, upheld on appeal. So you may not want to be so flippant if you decide not to cooperate. And in the decision from Justice Martin, he tried to make the argument, number one, that he wasn't properly identified because he used the wrong middle name. That's not a very good legal argument. But secondly, that section 708 was the only way that the court could proceed, which again, I told you goes nowhere. Never try to make that argument. They have common law powers to do whatever they want for the contempt of court, and they can basically make up anything they want to do, as long as the accused generally gets the ability to consult with a lawyer at some point in time. Next, this is unreported decision 2019. This is a case I was involved in. R versus Lofty. I represented Mr. Lofty. This is a very interesting case, not just because I was on it, but it can show you how difficult it is on these cases. 18-year-old witness was a youth at the time. It was a youth co-accused that had already pled guilty and was called as a witness for his adult co-accused. He essentially turned 18. That's why I can list his name. He voiced his pleasure with being on the stand, and Justice Taves warned him not to leave when he asked him to wait outside the courtroom while he addressed the legal argument between counsel. Lofty then left the building and did not return. Boy, that's a mistake. He was told, don't leave. I listened on DAR, and he was told, don't leave. Ultimately, the accused, not Lofty, but the accused in the home invasion pled guilty and received a sentence of 8.5 years or 8 years in prison. Lofty, who had a youth criminal record, was Indigenous and was on schedule to finish grade 12 and was sentenced to 12 months imprisonment. Defense, that being John Robbins, raised the issues that, unlike the other cases where I would say that the contempt was a bit more deliberate, Mr. Lofty didn't have the benefit of speaking with counsel during a break in the proceedings. He didn't have a significant amount of time to consider his actions before deciding to abscond, in addition to real threats from his family. So I'm saying that this was more spontaneous, that he just kind of got up and left after saying he didn't want to be there, versus you have somebody on the stand who says, oh, I'm not going to cooperate, and they're given several hours or a day to speak to counsel and think it over. I tried to draw a distinction. Justice Taves was not going for it. Justice Taves stated that Lofty was receiving a low sentence of 12 months due to his quote-unquote glad-do considerations. To the credit of Justice Taves, the Manitoba Court of Appeal has been clear that glad-do principles can apply to individuals sentenced for contempt of court. So if you ever have a judge or justice that tries to tell you they don't, they're wrong. They do. That was one of the reasons that LaValle was reduced from 10 months to 5 months in the case we previously spoke about. The outcome for Mr. Lofty was not surprising, as Justice Taves gleefully announced, "You're back," to Mr. Lofty upon entering the courtroom and seeing Mr. Lofty in custody and in attendance for his contempt hearing, along with the sheriffs and me seated next to him. I knew when he said that it wasn't probably going to go very well for Mr. Lofty. So when it comes to criminal contempt in Canada, especially as a defense lawyer, number one, remember, give advice to a person who's considering not testifying. Tell them this is really what you got to reconsider. If you refuse to testify, there's going to be serious consequences here. And basically your evidence is generally going to be used in the court anyway. So you're still going to be seen how you're going to be seen by those that you're worried about. And then secondly, when it comes to representing somebody in contempt proceedings themselves, pack a toothbrush. They're going to jail. The only question is how long. It's interesting that we don't really see any provincial court decisions ever on contempt. It's almost always Superior Court. It's almost always gangster trials. Whether that's for the reason it's dealt with in other ways, the Crown just lays a fail to attend for the person refusing to show up, or they charge them under 708 in the criminal court, provincial court, where judges just don't really cite people in contempt very much. There just seems to be two different tracks. And if you're in Superior Court, it's a whole different ballgame. You're looking at generally a 12 to 36 month range. The process is pretty elastic. The judge can proceed as they want. And if you ever tell a judge that they should recuse themselves because it seemed like their mind is made up, hit the deck, call John Robbins because he wants to witness it. And that is the law of criminal contempt in Manitoba and Canada as it stands.
Okay, thank you both for that. And I'm just gonna ask you to stick around for a minute here. I'm gonna stop sharing the screen. And if anybody has any questions, feel free to pipe in and ask those. You can unmute yourselves if you're on Zoom. Anybody present?
I
here
have a question for
questions?
Jane, actually, in the youth. Can I ask a question?
Sure,
I know I talk a
absolutely,
lot, but
Jane.
I do that sometimes. So, Jane, I have, there's something that bugs me when I'm trying to understand the distinction between youth law and adult law, which is when somebody is 17 years old and 17 years, 364 days, they are treated differently than somebody who is 18 years on the dot. That has always struck me as unfair, and I don't get it. So I guess I have two questions. Number one is, have you ever seen any cases where somebody tries to bring medical evidence or social evidence of some sort to have somebody's moral blameworthiness reduced because they're only 18 years of age? We know the Court of Appeal says being a youthful offender is a mitigating factor, but have you ever seen a case where they've tried to do that? And then my second question is, when you were talking about delay in Jordan, you're talking about how youth's minds, their brains are still developing. They're not the same as adults. And that when you're a kid, a really long time is different than when you're an adult. But I'm going to throw a curveball to you. I actually agree with one of the justices who said, well, you got to look at it as a case by case basis, because a 12-year-old is much different than a 17-year-old who's 17 in 364 days. So should we be treating a 12-year-old the same as somebody who's a day short of their 18th birthday? I mean, when we look at adult sentence applications, we draw a distinction between those who are 12 and 13, right? Versus those who are 16 or 17. So to treat youth from 12 to 17 as a monolith, I don't know. I'm sure you agree with that, but I can understand how maybe that's not the case. Yeah. The two questions being, have you seen anybody try to bring any evidence to get somebody's sentence or more blameworthiness reduced when they're just 18? And second, what do you think about the fact that, somebody who is 18 and a bit is much different than 12 years old when it comes to Jordan?
Yeah, so I think that the arbitrary delineation of once you're 18, you're an adult is, I don't know historically where that came from. It's been around for a while in multiple common law countries. So it's an arbitrary distinction. I think that the evidence suggests that when we're looking at, the interplay of the amygdala and the striatum and prefrontal cortex, that development actually doesn't fully happen until you're 25 years old. So there's potentially an argument to be made that the YCJA should extend to 25.
It sounds like a great case for the youth office.
Yeah.
You get the right 18-year-old, right? Well, really?
Yeah. But no, so I don't really represent that many 18-year-olds.
Sure.
But yeah, I think that it is an arbitrary delineation in terms of what the court was saying. Yes, obviously there's a difference between a 12-year-old and a 17-year-old, and the concern is that, when we start changing the Jordan ceilings, then we would have to change it for, as you're saying, adults that are mentally compromised, right? That might have a cognitive age that's lower. So then should Jordan apply differently to them?
You open up a whole bag that nobody wants to open, right? Fair enough. Thanks.
Anyone else? Any questions? Again, come on in the chat. Mark?
Yeah, he had asked if the delay between conviction, or I guess guilty plea, either one, and sentencing, does that matter with youths?
No, so it's once you're convicted or pled guilty, whenever there's a
So it's the same as adult sentence, essentially. I have a question for you. Has the youth unit or anyone seen any youth cases where they're not 16 or 15 or above, and it's murder or manslaughter where they didn't try to go by way of adult sentence?
Have we seen any?
Where they just go with the youth sentence?
You know what, Hillary would be the better person in terms of stats on that. But yeah, typically it seems like anytime there's a murder, that adult sentence is being whispered somewhere in the back.
I can help answer that as well. As somebody who practiced in the North for a long time, I find that there's a huge distinction between seeking adult punishment up north versus in the city. I do.
More up north?
No, hardly ever. I've done one where the kid was 17 and he'd already served a youth max sentence. And we agreed to a manslaughter. I agreed to an adult sentence years ago, and I agreed not to seek less than 8 or 9 years. That is the only, I can think of maybe 1 or 2 adult sentences up there. Almost always, they are youth sentences. And almost always the Crown, they may, kick their tires a bit and mention it depending on who your Crown is, but they don't ever proceed that way up north. They always proceed in the city, which would be a super interesting case study, quite frankly. Why? I have some thoughts on why, but I'm not going to say them out loud. But yeah, why?
Well, it reminds me of the US and the death penalty, right? You got the death penalty on the table, so they're gonna plead to the lesser sentence.
Even for
Same with youth, right? I'm gonna go adult sentence. Oh yeah, you're gonna take the max as a youth? Okay, here we go. That's how I see it.
Sure, but it's also, we're going to come after some underdeveloped, dumb kid, unsophisticated kid with all these issues in the inner city of Winnipeg, but we're not going to do it in Thompson or Shamato or Puckenawagan. Why? What's the difference? I mean, I don't know.
Yeah, and oftentimes, sorry to interrupt, but yeah,
They come from there, or the family
Exactly,
comes
yeah.
from there anyway. So what's the distinction is, justice should be uniform as so much as possible. And it could also speak to the potential of, if anyone was at the criminal defense conference last year, about points being raised to the Chief Justice about seniority of certain prosecutions in different parts of the province versus those in Winnipeg, and how offenses are prosecuted. Is it uniform based upon how much experience a prosecutor has in one part versus another? Anyway, interesting procedural questions.
No, it's very interesting.
Yeah, I've dealt with quite a few youth murders, and they tend to always just throw out adult sentence immediately. But then once you point out issues with their case and they think they could lose potential stays like acquittals or things like that, then they tend to immediately come down, fine, we'll agree to a youth sentence, and try to throw a bunch of stipulations onto it. But
Yeah, and it would be interesting to look at like the media coverage too, right?
Yeah.
How that relates to the adult sentence notice. And I think that there's some correlation there.
okay, well, I want to thank everyone, first of all, for joining us, and thank you very much, Jane and John. We appreciate you coming today. That's the end of today's session. Have a great day, everyone.